Hi friends, ladies and gentlemen. Today I would like to speak something about my people, that is advocates or lawyers, and of course about their profession also. Advocacy has long been regarded as a noble profession because lawyers are not merely representing their client only. They are officers of court or the justice and guardians of a rule of law. Advocates are not confined in courtrooms only. They often shine in social, political and public spheres as opinion makers, leaders and guides to the society. Many of them are in key posts in power structures like cabinet ministers and all. The society places immense trust on advocates to uphold fairness, ethics and constitutional values. It is needless to say that the advocates require independence, professional dignity and an atmosphere that allows them to perform without fear or undue pressure. It is true that most of the advocates are trying to perform their best, keeping high and unquestionable standards in spite of several odds. It is also true that a small section of members are engaged in misconduct through unethical means or intimidation or misuse of process of law, which diminishes the dignity of profession and weakens the public confidence in justice system. What is meant by professional misconduct? Professional misconduct of an advocate refers to an act or a violation of an act that violates ethical standards or duty to the court or duty to the client. Under Bar Council of India, there are some prohibitions. Prohibitions against soliciting and advertising, engaging in some other businesses and dereliction of duty like misappropriation of clients' money, misleading the court and changing side and suggesting bribery. These are considered to be major misconduct of an advocate. Now it is worthwhile to note that engaging in legal awareness classes will not amount to professional misconduct. Sharing legal knowledge to the public is a recognized public duty of advocates. Writing articles or books on legal subjects also will not amount to professional misconduct. The thing is that all these are to be done without crossing the limits into advertising or soliciting or commercial business. As regards to the procedures in connection with the professional misconduct, State Bar Council is empowered to take action against the advocate. As per section 35 of Advocates Act, the State Bar Council can reprimand or suspend or remove the name of the advocate from the role in proved cases. Against such orders, appeal to be filed before Bar Council of India and subsequently before the Supreme Court of India. In a proceedings on professional misconduct, there must be a jural or professional relationship in between the complainant and the advocate. In the absence of such a relationship, no proceedings will lie. In a recent judgment, the Supreme Court held that the disciplinary action taken by Maharashtra and Goa State Bar Council is illegal. There was no such relationship. The complainant filed complaint against the advocate appearing for the opposite party, not for him. The advocate was not appearing for the complainant in that case. So there is no jural or professional relationship in between the complainant and the advocate. The Supreme Court held that the order of the Bar Council is unreasonable and cryptic and laconic. In that case, the Supreme Court imposed a cost of 15,000 on Bar Council, State Bar Council, for such an order, such an irresponsible order. Supreme Court also imposed 50,000 fine on to the complainant for harassment. This judgment of Supreme Court is a strong reminder that the advocates must be shielded from baseless attacks to allow him to perform his duties without fear of unnecessary pressures. Advocate nowadays faces other type of attacks also. They are facing physical attacks even from court premises. Serious discussions are going on in advocates community. A strong legislation is also suggested to ensure the safety of advocates in order to strengthen the confidence in justice delivery system. Thank you.